Welcome. We're here. I'm David Herzberg. I'm one of the editors of the Social History of Alcohol and Drugs. That's the Journal of the Alcohol and Drug History Society. And I'm here with David Pozen, professor of law at Columbia University. And we're here to discuss this book. Let me see if I can get it close enough for you to see. The Constitution of the War on Drugs. It's actually a really fascinating book that brings up a lot of important elements of the history of drugs and drug policy in the United States that I've been studying this subject for decades, and a lot of things that I wasn't aware of. So really fascinating. I think it's got a lot of useful stuff for us to know. One of the things that's useful to know about the book is that while it is available for purchase at Oxford University Press and such, it is also available on its open access. You can get it without even paying for it. And the way to do that is you search on Google for the author's last name, Pozen, and the letters SSRN. That is the website that hosts this open access volume along with a bunch of others. So if you search Pozen SSRN, it'll take you to the book and you can read it after you learn about all of the fascinating things it has to say based on our conversation. So welcome. Let me say, in general terms, this book starts with a question. You note that there are all sorts of seemingly germane constitutional bases on which one could question or challenge drug war policies, this whole constellation of punitive drug prohibitions. And yet, you notice, even in a moment today in the 21st century when drug law is kind of under question, there's both internationally and in the United States, virtually no one seems to be taking up those constitutional possibilities to challenge drug prohibition at this kind of deeper fundamental level. And so you start out by just asking the question, why not? Yeah. And as it turns out, luckily for us, history is central to this answer, because as this book demonstrates, each of these challenges has been taken up at one point or another in U.S. history, and there's a story there of why it was taken up when it was, and why those challenges failed, and not only failed at that time, but also failed to become precedent that is then there to be taken up and used in today's reform efforts around drug policy. So if I can just ask you to start by introducing to us to what are some of the main avenues of constitutional challenge that drug policy reformers in the United States could be using but are not.
Great. Okay. Thanks, David, and thanks for having me on. It's an honor to be here with such an eminent drug historian whose work I've learned so much from. I would first just say on your opening observation about how the book starts with a puzzle, that I think it's puzzling multiple times over, that we're not talking more about the Constitution in relationship to drug policy and drug prohibition. I say that because in prior periods of U.S. history, as the book documents, there were active constitutional challenges to drug prohibitions and drug penalties, not just once, but in multiple times, cyclically in U.S. history. Also, the drug reform movement today invokes themes like individual liberty and racial equality and rational government decision-making that are some of the central tropes of modern constitutional law. So it's awkward from a common law perspective to hear reformers demand liberty, privacy, and racial justice and not invoke the Constitution, given how central the Constitution is to those themes elsewhere in the law. Third, the U.S. is known comparatively as a country that constitutionalizes almost every social issue. We fight constitutionally about reproductive rights and gun rights and affirmative action and name your issue. And yet drugs are one issue where we don't fight constitutionally. So how did the drug area get deconstitutionalized? And then finally, constitutional courts around the world, starting in Latin America, it's now spread to Europe, Africa, a little bit in Asia, have found certain forms of constitutional drug rights, usually rights to use and possession of small amounts of certain drugs. So there's a global movement going on of finding what we might call drug rights in national constitutions. In a sense, we birthed that movement in the U.S. In earlier generations, and yet now it's taken left us behind. So on numerous levels, I find it strange that no one's asking these questions about are drug prohibitions constitutional, under what circumstances, with what penalty structures. To the extent people are having constitutional fights over drug policy now, it's mainly about enforcement. Can the police use certain tactics to enforce drug prohibitions, like stop and frisk, or kinds of profiling, or surveillance, or urine testing, or no-knock raids? Those are important constitutional issues, but they're all downstream from the first-order question of whether and when drugs can be prohibited in the first place. And a long line of legal commentators have said, if you allow popular, widely used drugs to be criminally prohibited, you're going to get really intrusive, invasive police tactics, if not a racialized police state, because how else are they going to enforce these laws? They're voluntary transactions. If you sell me drugs, there's no victim. No one's going to report that crime. And they're portable, they're small. You're going to need really aggressive policing to get at that conduct. And so I want to, in the book, return us to these, what I view as more fundamental fights over when drugs can be prohibited and on what basis, before we get to the enforcement questions. As for whether is it crazy to think that drug prohibitions could be challenged as unconstitutional, I'll just briefly say a lot of parts of the Constitution have been and could be harnessed to challenge these laws. They include protections of liberty and privacy, now mainly done under the Due Process Clause, protections for racial equality and against racial discrimination under the Equal Protection Clause, federalism limits on national government power, also under the Equal Protection Clause, requirements that laws be at least minimally rational and that like offenses be treated alike. So if cigarettes or alcohol are as dangerous or more dangerous than another drug, might it not be permissible to nonetheless prohibit that other drug much more harshly? Freedom of religion and freedom of speech arguments have been made with some success under the First Amendment. The Eighth Amendment has a prohibition on cruel and unusual punishment and excessive fines. Those also are applicable to drug laws. And I could go on. So it's just to say there are actually quite a few resources in the text of our canonical legal document to fight punitive drug policies, even though, again, we've largely lost touch with those fights.
Yeah, that's great. I mean, and if that alone doesn't convince you that this book is worth digging into, I mean, it's absolutely fascinating and important as well. So before we dig into a couple examples to show how this worked, one more broad question that it seems that many of there was a period in which a lot of these different tools were brought to bear on the question of drug policy, and challenges to drug prohibition were leveled on these bases at a particular period in recent history, in the 1960s, 1970s, maybe some leaching into the 1980s, early 90s as well. And these came from all different directions. As you said, all of those different bases, they have different political valences, they speak to different constituencies, and yet many of the challenges in the most recent wave came at this particular time. And I wonder if you could say to historians here, like, well, how can we, what would we name this period?
Yeah.
Like, why did it happen then, and why did it go away?
That's a fascinating question. The book focuses a lot on the 1960s and 70s as this moment of possibility for constitutional drug rights or limits on certain governmental anti-drug policies. And it's basically a story of a confluence of political opening and a legal opening. So politically, as you know as well as anyone, drug policy and drug politics are in flux in the 1960s and 70s for all kinds of reasons. Changing patterns of drug use, new constituencies for drug reform, including college students, college-educated professionals. The counterculture is rising. And when we get to President Carter, we have from the highest levels of government someone expressing openness to decriminalization, at least of cannabis. And so politically, things are a bit unsettled in the 1960s and 70s about where we're gonna go with drug policy. The framework legal statute that emerges from this period, the Controlled Substances Act from 1970, now we associate with punitive prohibitionism and the war on drugs, was a more mixed bag at the time, combined some public health, kind of medical responses as well as criminal prohibitions, speaks to the openness of the period. So that's, I think, probably a well-known story about how drug politics are complicated and fluid in the 60s and 70s. Legally, though, something similar was happening with constitutional rights doctrine. The Warren Court, this particularly liberal Supreme Court, from 1953 to 1969, establishes a bunch of new protections for personal liberty, privacy, protections for criminal suspects and defendants, that and into the Burger Court that followed it after 1969, unsettled a lot of areas of constitutional rights doctrine and gave lawyers new avenues to challenge punitive policies. I'm sure we'll talk about some specifics. But just to say, the political ferment was matched on the constitutional side with a period of upheaval in the doctrine. And it wasn't really until the 1980s that the doctrine fully settled into into a stance of allowing the government to do almost anything when it came to drug regulation.
Yeah, that's really fascinating. I mean, to think of another element of the ferment that, a lot of people are aware of it in drug policy at that time, but that it coincided with this era of constitutional interpretation or ferment in that. I think that's really a productive intersection. So let's dig into a couple of examples of these, and one of them that seems particularly intriguing to me is one that a challenge that was successful in some areas of life, but not successful in the area of drug policy, and this is this right to privacy that is kind of inaugurated with Griswold. Yeah. And I'd like to just tell us the story about why some groups were able to achieve new rights based on this claim to privacy, and why that wasn't successful for drugs.
Great. Yeah, a key case in the launch of this rights revolution, if you will, at the court was Griswold versus Connecticut, handed down in 1965. And this is a famous opinion in which the court, for the first time, identifies a right to privacy. It's actually unclear where textually it would be housed for a while, ends up in the Due Process Clause later. But there the court strikes down a state ban on contraception in the home for married couples. And that opinion could have been read very narrowly, just a protection for married couples to access certain types of contraception in the home. Or, as the dissent charged, it could have established a general right to privacy with which you could attack any and all laws that got at your personal autonomy too much, especially in the home. And then Griswold leads to Roe versus Wade within a decade, and a more expansive understanding of the right to privacy. It's clearly not just going to be in the home, and it's going to be something more robust. Drug lawyers quickly figure out that Griswold is a tool with which they can attack drug prohibition and other types of vice regulation. Why? Because people also use drugs in the home, and it also has unclear negative externalities for third parties in many cases, so the behavior looks private in nature in some accountings. And they start wielding Griswold to fight particularly marijuana prohibition after 1965. In a case this seems fantastical in hindsight, that a right to privacy we now associate with kind of sexual autonomy, reproductive rights, would apply to drugs. The book amasses a number of commentaries from people at the time where they seem to think it very plausible that Griswold would apply to drugs. You have retired Supreme Court Justice Tom Clark saying around 1970 that he thought it likely that his former colleagues on the Supreme Court would strike down a ban on marijuana possession under the logic of Griswold. You have leading academics saying the same thing. You have the American Bar Association taking a supportive stance. You have a California legislative committee that in a 1974, as I recall, report said that Roe seems clearly to compel a right to personal possession and use of marijuana. It was very unclear what this newly established right to privacy would cover, how broadly it would sweep, but it seemed potentially quite applicable to personal use and possession of drugs. And you get some state Supreme Courts finding on a privacy rationale a kind of drug rights, most famously Raven versus State in Alaska, not quite using the logic of Griswold, but from this period basically from 1965 to the end of the 1970s, whether and to what extent the right to privacy would become the key linchpin of drug rights was highly unsettled, litigated extensively, and threw off a number of victories for drug defendants until it's ultimately largely shut down outside of Alaska by the end of the 70s.
Yeah, and just to be clear, how did it get shut
down? The basic answer, I could give a lot. I'm trying to figure out what level of legal
historian level.
Yeah,
level.
Okay. It basically gets shut down because the federal courts realize that they've opened the floodgates in Griswold to attacks on all manner of vice regulation and all manner of assertion of personal liberty claims, from riding your motorcycle without a helmet to wearing your hair long in an institution that requires you to keep it short, to drug claims. And I read the courts in this period as wanting to pull back on what they started in Griswold and rationalize the doctrine and limit the ability for people to win these privacy and liberty claims. And the marijuana cases are key here, I think, in shaping the privacy doctrine to be less amenable to challengers winning. So the actual legal form that takes is the court clarifies over the course of the 1970s that, okay, actually, if you want to win a so-called substantive due process claim, a claim of substantive right, like a privacy claim under due process, you're going to have to first establish that the liberty or privacy infringement was fundamental. You have to make a threshold showing of a fundamental rights abridgment before we'll take your claim seriously. And this was meant to weed out, no pun intended, lots of claims the court didn't want to honor. And no judge was willing to say that your right to smoke pot or possess whatever drug is fundamental. And that just proved an insuperable barrier. As I say in the book, I think it's a poor way to capture the stakes of a lot of these drug debates, because rarely were the challengers claiming my right to use whatever drug, say cannabis, is utterly fundamental and needs to be treated much differently and more seriously than all manner of other liberty or privacy rights I can contend. Instead, the structure of the argument was normally, I have some non-trivial liberty and privacy and autonomy interest in ingesting the drugs I want to ingest. But the real problem is that on the other side, the government's interest in criminally prohibiting that behavior is very weak. The criminal prohibitions are proven failures under any definition of failure. They create all kinds of additional harms, and they don't actually end up promoting public health. They are themselves criminogenic and so on. And so what you really need is for courts to balance the liberty or privacy claim against the government's regulatory interest, as courts abroad are now doing in finding marijuana criminal prohibitions can't stand. But when the US Supreme Court said, no, you have to make this showing of fundamentality, that proved fatal to the privacy and liberty claims here.
It's interesting. I haven't read that case, but I'm willing to bet they didn't call any historians to discuss whether using drugs is a fundamental human behavior.
Yeah.
That would be an interesting.
They're
interesting
utterly
thing.
dismissive of that, and in a way that is intellectually, unsatisfying, to say the least. But it seemed to them like self-evident that obviously drug use couldn't be fundamental. At one point, they even, one court said, you yourself describe it as a recreational drug. You have therefore proven it's not fundamental because
they said as they sipped their coffee. So, well, that's really interesting. Let's look at one more kind of in-depth example here, and this is one that'll be familiar to U.S. historians of drug policy, and this is the ban on cruel and unusual punishment or the protection from that, and this one is embodied in another Central Supreme Court case, Robinson v. California, and why didn't this lead to more radical challenges to drug war policies when it was the Supreme Court itself that kind of stepped into that situation directly with drugs even?
Great. I mean, on the Eighth Amendment challenges to drug prohibitions as cruel and unusual punishment are really drug penalties. There are two main lines of doctrine in the 1960s and 70s that take off and actually yield a number of wins before that too gets shut down. And that's a pattern in the book. In this period of fluidity and ferment, challengers winning in the lower courts and state courts quite a bit before ultimately the doctrine turns against them. So Robinson is the famous case where the Supreme Court in 1962 evaluates a California law that, as the California courts had construed it, made the status of being an addict a crime. And the Supreme Court said that amounts to cruel and unusual punishment when someone is, for the mere status of being an addict, subject to criminal sanction. And that's a very strange ruling on so many levels for lawyers. There's very little actual Eighth Amendment analysis in Robinson. It's more of a set of normative propositions than the standard stuff of constitutional interpretation. Text, history, structure isn't really gone into in any depth. And it's pretty clear to me that that would have been treated as a substantive due process decision after Griswold. But Griswold hadn't yet come around and established substantive due process. So that would be, I think, the more natural way to analyze it. But in any event, the court, clearly upset by this California law, it finds outrageous, says you can't just criminalize the status of being an addict. And the big question it opened up immediately for lawyers was, if it's impermissible to punish me for the status of being an addict, shouldn't it likewise be impermissible to punish me for doing things incident to my addiction, like buying and consuming the substance to which I'm addicted? And a number of lower courts in the 1960s find that Robinson should be read that way, to apply to conduct that is in some sense involuntary or compulsory in light of one's addiction. But then the Supreme Court re-enters the picture and it actually sends somewhat mixed signals. But by the short of it is, by the 1970s, the courts pull back from that potentially more expansive reading of Robinson to cover not just the status, but acts that flow from a status that you can't control, for fear that it would unwind too much of the criminal law. There are all kinds of behaviors, judges pointed out, that are in some sense involuntary that we engage in, and also very hard to administer a doctrine that asks in every given case, you were found with this drug, were you able to control yourself with regard to it? So it becomes a very fact-intensive and labor-intensive inquiry that the judges didn't have the stomach for. So, so after this period in which Robinson really could have benefited, basically carved out a special status for addiction under Eighth Amendment law, that falls apart by the 1970s. The other line of Eighth Amendment doctrine, which actually is much simpler and to my mind a more natural way to think about the issues, is not that addiction has a special status per se, but that the punishment has to fit the crime. And it actually wasn't established under Eighth Amendment law until the Warren Court that it protected anything other than barbaric modes of punishment. So the old understanding of the Eighth Amendment was just you couldn't use the rack and the screw. But any prison sentence, no matter how long, no matter how extreme seeming in light of the crime, was not an Eighth Amendment problem. But the court clarifies that in this mid-century period, that if the punishment is grossly disproportionate to the gravity of the offense, the moral desert of the offender, that too can be an Eighth Amendment. That can be cruel and unusual punishment. And again, lawyers immediately perceive that nonviolent, non-trafficking drug offenses, where people are getting a decade or more in prison for basically conduct that, if it harms anyone, is probably themselves, or at least primarily, looks like it may be grossly disproportionate, to the more. And a number of lower courts and state Supreme Courts start striking down drug penalties on this ground. Not that addiction is special, but just the punishments are excessive in light of the crime. And that could have really gone somewhere as a break on the war on drugs. Sure. But the Supreme Court stepped back in at the back end of this period in the really the 1980s and made it clear basically that that would only be applicable to the death penalty for the most part. And it would be almost impossible, short of a death sentence, which was very, very rare in the drug context, to win on a challenge of gross disproportionality. So it's a sad story, that chapter, I think, in that the Eighth Amendment kind of comes to life in the 1960s and 70s, looks like it might be a real check on over-punishment and a barrier to the mass incarceration that would follow, and then falls apart.
Yeah, I mean, I think this is the chapter where you point out, kind of as an aside, like the court is saying, oh, it'll be too hard, it's a slippery slope, and you point out, like, well, everything has a slippery slope if you derive it far enough back to its fundamental maximum. I mean, like, and it's the court's job to set up the arbitrary limits, to have that courage, and it's interesting that they quailed at that moment, or also to wonder if making the right decision here would have these broad ramifications. Maybe it's worth thinking more broadly.
Right.
Not that I would know where that would result.
Yeah.
So I mean, you have.
Well, I was just saying that judges constantly say in this period, it is tantamount to lawlessness to ask us to say, is 12 years excessive, but 11 years is okay? I mean, this isn't judicial at all. It's barely law to try to figure out what's disproportionate. And so better for us to just say that it's all not cruel and unusual punishment and stick to this uncompromising formalism. But the great irony is that in the decades since the U.S. courts pulled back on this Eighth Amendment doctrine, shouting out that to judge the proportionality of a conviction would be beyond the judicial ken, a whole new style of reviewing rights claim has taken off in basically every other country in the world except for the U.S., called proportionality. And it is now, in the rest of the world, it is a foundation stone of the rule of law that judges do this kind of structured balancing of just when has the state gone too far. So it's deeply ironic that the U.S. courts quail, as you say, when asked to do something that has become the central judicial task elsewhere in the world.
And then that they do in other contexts, at least if I'm reading you right, in other contexts, they recognize slippery slopes and say, well, here's where we're going to put, this is the line between what's reasonable and what's unreasonable.
Right.
So, really, so, I know you're traveling today, and I don't want to keep you here forever, so we're going to stop the deep dives into specific examples there. But let me just tell you all listening here that each chapter has a similarly gripping kind of like, and to me, unfamiliar in a lot of cases, like real stories of deep challenges to the constitutional basis for these laws, and then and the story of how the court stepped away from them, or how they lost steam in one way or another. And I strongly encourage you to pick it up. So I want to jump back to some of at the bigger picture and ask a question. There are areas in American life where challenges to constitutional prohibitions, maybe unconstitutional prohibitions, have been successful in changing the law based on constitutional challenges. That this is sometimes, this has been some successes of the civil rights movement, feminism, and LGBTQ movements. So there have been times when this sort of thing has resulted in dramatic change, not just to the pro forma law, but to the way that we lead our lives. And you talk a little bit in the book about why, analytically speaking, why some of these are successful, whereas in this case, the drug case, it wasn't. If you could just talk a little about that.
Yeah, I mean, there's a big question, but there is a literature in constitutional law about the question of when and why certain social movements win with their substantive rights claims when most lose. And famous case studies include the civil rights movement, and more recently, gun rights and gay rights in particular. The road to Obergefell and the constitutionalization of same-sex marriage, and the road to Heller and the recognition of the individual right to bear arms. And it's a difficult literature because it's kind of winner's history, and there's like an N of 3. Most social movements lose. So it's hard to extrapolate general lessons on what works from that kind of sample. But drawing on that literature, I try to say how the drug reform movement didn't have some of the properties that literature identifies as important to constitutional success. That includes what the Supreme Court sometimes calls the status of the group making the rights claim being a discrete and insular minority. That is a group that has some identitarian glue, like they understand themselves to be part of a cohesive group, and they're recognizable to each other as such. And this makes for more effective coalition building and advocacy. And drug users and reformers weren't so much this discrete and insular minority that could band together as a diffuse and anonymous plurality of the population. They're everywhere, and their numbers are huge, but they're not organized. They don't see themselves as part of a community, and people remain in the closet, if you will. And so, there's something about the structure of the drug community that isn't amenable to the kind of successful litigation campaigns we saw elsewhere. But beyond that, we have a kind of inability to forge the kind of multiracial coalition that I think could have been most powerful here. So as the war on drugs ramps up and it becomes more and more obviously racialized and destructive for minority communities, you might think you would get a kind of anti-prohibition coalition of, on the one hand, black civic and political leaders and kind of white elite liberals who can find common cause in fighting this set of destructive policies. But for complicated reasons, that coalition never comes together. The black community is internally fractured on its view on a lot of these drug laws at pivotal moments. On the one hand, fearing the harms they're visiting on their communities. On the other hand, fearing the harms the drugs are visiting on their communities, in some points seeking punitive responses. White liberal elites largely retreat to the closet. There's this moment in the 1980s when Douglas Ginsburg, the judge on the DC Circuit, is nominated to the Supreme Court. The nomination goes down because it's revealed he smoked pot when he was a professor. And I kind of diagnosed that moment as being another one of possibility where instead the people retrench from pushing for a more liberal drug policy. So there's at a larger level, there's also not a kind of interest convergence across different potentially politically powerful constituencies to push for drug reform in the courts and beyond. And then finally, I'll just say that there's Reva Siegel is a eminent constitutional historian who says that the most successful constitutional rights campaigns always tap into a kind of common language of our shared history and heritage. And on the one hand, they're pressing novel claims, give me a new right. On the other hand, they're invoking this old tradition and trying to put themselves in its line. And that the drug lawyers, like from the ACLU and NORML, the National Organization for Reform of Marijuana Laws, who are litigating a lot of these cases, they're relying almost exclusively on the latest Warren Court hits, the new right to private, and they're not calling on this longer anti-prohibition tradition, which was tested with alcohol prohibition in the 18th Amendment, but you might say, kind of vanquished with the 21st Amendment when we got rid of alcohol prohibition. And I think you could tell a story about how the very idea of drug prohibition is kind of anti-canonical in the U.S. tradition, and articulated a case about something positive that would come out of drug liberalization, not just the state is going too far, but if you allow this behavior, something good will flow from it. And so on all of these levels, I guess I see the drug rights movement of the 1960s and 70s as not set up to win, not having these structural and ideological features that have allowed other movements to win. And as I say in the book at one point, in the 1960s and 70s, the proposition that you would have a constitutional right to smoke pot in your home was way more mainstream than the idea that same-sex marriage or an individual right to have a gun in your home would be constitutionally protected. So it can't just be something about the intrinsic legal merits of the claim. Something else is going on. Nor can it be something about the number of people put at legal risk because there are so many tens of millions of drug users potentially at risk from criminal drug prohibitions. So that's a long answer and not fully satisfying, but I think it is an important question.
Yeah, it's a lot to think with. That and one of the things that kept coming up in my mind when I was reading in this section of the book was respectability politics. And thinking about from groups like, for example, Black Americans who are trying to knock on the door, like the effort to appeal to that common those shared values led to this kind of respectability politics that, it would have been shocking for me as a historian to go back and see someone thinking, okay, the strategic move is going to be to ally ourselves with people who use drugs.
Right.
And then on the other hand, there's the question of, you say, they were set up to fail, but I'm thinking about the argument that the goal, if the goal of at least some of the drug reformers was to make sure that white kids could smoke weed, then it did sort of succeed, and it went just far enough to meet the needs of that particular activist group and no further.
Right. Now I talk about that too. Yeah, none of this is possible without a kind of, the centaur state at one point. Lacan's. I'm going to screw up his name, but
you got me thinking of the psychoanalyst instead Lacan, but no, it's
Lacan.
Louis Lacan.
Thank you. Okay.
There we go. Together.
All right, okay, we could cobble it together. Shows how I'm a lawyer. This idea that this is only possible because we have a centaur state that's relatively liberal for those at the top who enjoy the most elite protected status, but brutally paternalistic and punitive at the bottom. None of this is possible without a punishment structure whereby white college-educated people are largely spared the harshest forms of punishment. Still, I still think, so I think it's absolutely true and crucial to the story, but not fully explanatory, in part because everyone is subject to some kinds of legal exposure under the war on drugs, even if the punishment is allocated so disparately and unfairly. Because short of criminal punishment, there's drug testing at work and security checks and reputational damage that you face, and lack of access to a clean and safe version of the supply of your favorite drug, and all kinds of lesser ways in which people's liberty is constrained under this regime.
Student loans.
So right. So
there's a lot of things that you can.
So it is when you have rates of use of illegal drugs at the level they were, where it's roughly half of the adult population admitting to use of drugs like cannabis, it's still the sheer prevalence of the behavior, which is technically all subject to criminal punishment, is bizarre. And in the 1960s and 70s, the period of greater doctrinal possibility that the book focuses on, you have a number of judges and eminent legal scholars saying, the legal system's going to collapse if you keep marijuana criminalized, because all the kids do it now, and they're going to find it. They're going to lose respect for the institution of the law. And their whole legal consciousness is going to change. Their whole orientation to law when they're all technically criminals, and they find that to be unsupportable. And of course, it's exactly what we did.
Yeah. Okay, I've got two more for you. Your voice holding up? Okay, so one of them is that you point out that the return of, or I don't know if this is, no, let me still revisit it again, the rise of originalism on the one hand domestically, and then as you already mentioned, the proportionality that's emerging internationally, that these are potentially bases for a reemergence of these kind of challenges, but also there's some obstacles to applying them. If you could just say a little bit about that.
Obstacles and trade-offs. So I view, in this cyclical tale of drug rights becoming legally and politically plausible at certain moments, I wonder whether we might be entering one now, given the kind of consensus, at least among experts, that the war on drugs was such a colossal failure, now a bipartisan consensus. But the precise arguments made in the 60s and 70s aren't going to work because precedent has closed the door. So, so then at the end of the book, I talk about how what has changed in constitutional law and practice that might create new openings. And the biggest thing that's happened at the U.S. courts is the rise of originalism. That is the idea that the Constitution should be interpreted consistent with the original understanding of any given phrase at the time it was drafted and ratified. And this is often held out to be a reactionary, conservative ploy to kind of roll back the Warren Court's liberal jurisprudence. And there's truth to that. But there, at least potentially, I see a number of moves one can make using originalism that surprisingly would lead to drug liberalization, though I wonder whether, one, the conservative judges who tend to wield originalism would ever do that, and two, whether if they did, it would generate such broad deregulatory consequences that progressives wouldn't think the game worth the candle. So what are the moves? The best historical scholarship that I know of on what people thought cruel and unusual punishment meant in 1791, when the Eighth Amendment is ratified, was remarkably expansive and probably would prohibit most long prison sentences for nonviolent offenses. So you have a very straightforward originalist argument that judges need to be policing long prison sentences much more, especially for nonviolent offenses. Originalism seems consistent with so-called jury nullification, where criminal juries not only vote on the facts, whether the facts prove that the defendant, did what they're accused of doing, but also can bring their conscience to bear on the law at issue and refuse to convict, not because they think the defendant's factually innocent, but because they believe the law is unjust. Famously controversial practice can be used to all kinds of mischievous ends, but can also be used to do some real good when the laws really are unjust. A lot of evidence that the Solicitor General of the United States admitted in a brief last year, suggesting that the original understanding of the criminal jury right was that juries could nullify. So that would, it's not a matter of doctrine, but I guess of legal practice, would allow for much more contestation around drug sentences, and more defendants would insist on going to trial, realizing that they could make a nullification argument, and it would change, I think, the dynamics of plea bargaining and then finally, originalist arguments that the national government has less power under the Commerce Clause of the Constitution than has been understood. So the Controlled Substance Act, the main federal statute, would be rolled way back, potentially. That one, really, you get into trade-offs, because if that reading of the Commerce Clause is right, then the Clean Air Act and the Americans with Disabilities Act also look like they might be challenged too. And then finally, although originalists don't love the Due Process Clause as a source of liberty, substantive liberty rights, some originalists think that other clauses of the Constitution, like the Privileges or Immunities Clause of the 14th Amendment, or maybe the 9th Amendment, protect substantive liberties. And so you can make an argument through those clauses on liberty, autonomy grounds. So there are actually no shortage of originalist moves you can make to get to liberal drug outcomes, though I'm skeptical as a matter of realpolitik it's going to happen. I'll be much briefer on proportionality, which is, because I already basically said it, weigh the infringement on liberty, autonomy, or the like against the government's regulatory interest and see if the latter is justified. And that's the method courts around the world, and a bunch of state Supreme Courts here, have been using to find particularly marijuana prohibitions unjustified. The U.S. Supreme Court has shown no appetite for proportionality. It seems happy to be a global outlier. But the state Supreme Courts are increasingly getting interested in it. And so I think if we see traction in the near term for constitutional drug arguments, it's going to be in the state courts, and it might have this proportionality flavor. I don't need to convince you that I have some extra special super right to use drugs. I just need to convince you that I have some liberty interest there, and that the government policy on the other side is counterproductive.
Okay. So this leads into the last question, which is that, this book is a book of things that didn't work. And yet you counsel, you advise people who are interested in drug war reforms not to abandon constitutional law. And one of the things that I think historians of popular constitutionalism and other related areas will be excited about is that it's not that you don't say, don't worry, next time we'll get the Supreme Court. Instead, you give a whole bunch of other ways that using the Constitution as a basis for reform, activism, policy change can be productive in a lot of ways. There's not just a single winning, like you win the Supreme Court or you've lost. And so maybe you just talk a little bit about, persuade us that this is that we should enfold this into drug policy reform efforts.
Okay, great. I mean, I think the Constitution is a highly imperfect tool with which to pursue reform strategies of all kinds. So I'm not, I don't make that suggestion at the end of the book because I have some notion that con law is where we always need to vindicate our rights claims. It's rather a more strategic analysis. So for one thing, in some areas, choosing to litigate your constitutional claims comes at an opportunity cost. That's less resources and energy you're going to be able to devote to your political or policy advocacy. But drug prohibitions throw out week after week, hundreds, if not thousands, of criminal cases. And all of those defendants have lawyers who have a professional responsibility to make out the best legal argument they can for their clients. And so, in a sense, you don't have to overthink the issue of whether we should try to convince judges of anything here, because you've got thousands of defendants who are facing prison time who need to be represented, and lawyers have a duty to try to make winning arguments. And if the book offers some, then they, if any arguments could stick, then the defense bar at least has a duty to try to mount the strongest arguments. And hopefully they might be reminded by the book that in prior periods there have been any number of plausible constitutional attacks on the kinds of charges their clients are facing. But beyond that, you can make constitutional arguments not to courts. You can make them state courts, not just federal courts, we just talked about that, but you can address them to Congress and to the Justice Department. And I think actually the more obvious place in which constitutional concerns should bear on drug regulation is in the political branches, so that when a question comes up like now about how should marijuana be scheduled, should it be a total criminal ban at the federal level, should it be medically prescribable under what, the fact that marijuana prohibition comes with a series of well-known constitutional problems ought to bear on the analysis. I'm not saying it should be dispositive, but I think it's really a dereliction of duty that legislators and regulators don't think they too need to take into account these constitutional considerations when they're formulating drug policies in the first place. And then finally, there's a notion of kind of a constitutional law as a rhetorical resource. We are a country known for worshiping its Constitution, and I feel like drug reformers have ceded the high ground unnecessarily in just acquiescing to this narrative that, of course, the drug laws themselves are constitutional. We just might think they're unwise or racist, or they are also potentially unconstitutional. And even if the courts haven't been, often for reasons of the limits of judicial competence and the judicial role, even when they recognize the claims might have some force, doesn't mean the claims are bad, doesn't mean they still can't be pressed in the court of public opinion. So that too suggests to me that there's scope for the common law to do something in changing the kind of, the texture or the tenor of the discourse around drug reform, even if no one's winning before this Supreme Court, the Roberts Court, with some great new claim. So it's a mixed bag and a mixed message, but I think on several levels, it is would be kind of foolhardy and almost incoherent to give up on the Constitution here, because it's at play whether you like it or not, and it's in the mix in all these criminal cases whether you like it or not. So if you care about drug reform, better to begin to develop some of these arguments if you think they're strong. Wait, I had one more point I was going to make, and I just lost my. But anyway, that's the. It'll come to me. That's the.
If you think of it while
Okay.
I'm closing up here, and I'll just point out one of the things that's nice about this is that you're taking a strategy that people might think of as belonging to highly educated elites backed by money, talking to other highly educated elites in courts, and you're saying there's actually real utility to the full range of people who are engaged with issues of drug policy, who have a stake in this, who want to have a voice in it. And you're saying, well, here's a tool, anybody can pick this up and make use of it. And so I think there's a lot to say to historians and a lot to say to people who are engaged with these issues in the present day. Now, let me wrap it up. Let me tell you again, we've been talking about the Constitution of the War on Drugs with the author David Pozen. I want to remind everyone that this book can be read for free. It is open access. You search the author's last name, Pozen, and then the website SSRN, and you can read it for yourself. I will tell you, it's a glorious read. It's very, I mean, from my point of view, it's got that kind of lawyer's precision. You know exactly what you're about to read. It goes through with wonderful efficiency. It's a remarkably short book given how much ground it covers. So I encourage you to pick it up, read it, and I hope that it'll give rise to a lot of fascinating historical conversations and maybe contribute some ideas and strategies to our effort to try to wrestle with the benefits and risks of drugs. So.
Thanks so much, David. I remember my last point. I'll say it as a final word, which
Yeah,
is
please do.
one thing, con law is a limited tool, but one thing it can do is in moments of political opening, if you can get a gain, it can entrench it to some degree against subsequent political rollback. So in a period of openness to liberal drug reform in a country where we've had kind of cycles of racialized moral panics around drugs, and when liberal gains are made, they're often yanked back in the next period. I would just suggest reformers would do well to get constitutionalized as much as they can of any progress they're able to achieve in a given period, looking ahead to the next panic. But thanks so much for the interview.
That's a really good point. I'm glad you remembered it and said it. Okay, goodbye everybody. Thanks for joining us.
Thanks for listening.